It is the legal battle cry that has reignited the fire of hope across the entire Southeast and sent a shiver down the spine of the judicial establishment in Abuja. Because for the first time since the devastating life imprisonment verdict was handed down, the global defense team of Mazi Nnamdi Kanu has come out swinging with a confidence that borders on certainty. The headline you saw is not just a wishful prayer. It is a calculated legal prophecy based on what the lawyers are calling a fatal error committed by the trial court. They are telling us today, Friday, December 5th, 2025, that the higher court will not just review the case, they will clear Nnamdi Kanu and set him free because the judgment that sent him to Sooto prison was built on a foundation of sand, a foundation made of a dead law that no longer exists in the Nigerian statute books. We are broadcasting this massive legal update to break down the explosive statement issued by the lead global defense consortium, signed by Barrister Njoku Jude Njoku, which has torn the verdict of Justice James Omotosho into shreds. We are going to analyze the specific sections of the law that the judge allegedly ignored, the accusation of judicial rascality, and why the defense team believes that the conviction is incurably defective. If you thought the legal road had ended, you need to pay close attention because according to Kanu's lawyers, the real trial is just beginning at the Court of Appeal and they have the magic bullet to kill the life sentence. The entire confidence of the defense team rests on one fundamental argument. You cannot try a citizen under a law that has been repealed. They are accusing Justice James Omotosho of relying on the Terrorism Amendment Act 2013 to convict Nnamdi Kanu in November 2025. But here is the catch. The National Assembly repealed that 2013 Act 3 years ago, in 2022, and replaced it with the Terrorism Prevention and Prohibition Act 2022. Barrister Njoku didn't mince words. He described the judge's action as breathing life into a corpse. He declared that a dead law cannot be used to try or convict any citizen, and by doing so, the trial court committed a blunder so massive that it renders the entire judgment null and void. To understand why this is such a big deal, we have to look at Section 97 of the new 2022 Act, which the defense team is citing as their shield. This section mandates that any investigation, trial, or legal proceeding commenced under the repealed act shall be continued and completed under the provisions of this act. The lawyers are arguing that the word shall leaves no room for discretion. It is a command. It means that even if Kanu was charged under the old law, the moment the new law was signed in 2022, the judge was legally bound to switch to the new rules. By refusing to switch and continuing to try him under the ghost of the 2013 Act, the judge allegedly acted without authority. Njoku stated the judge had no authority to pretend that the old law still existed. This is the core of their argument. The trial was conducted using a rule book that had been thrown into the trash can of history. But the government has its own argument, likely relying on Section 98(3), which typically preserves actions taken under a repealed law. But Kanu's team has already anticipated this defense and dismantled it in their statement. Njoku accused the trial court of misinterpreting this section, arguing that it simply saves earlier steps taken, like the arrest, the filing of charges, and the seizure of materials, but it does not authorize future convictions under the repealed law. He said it does not resurrect a dead statute. No court, not even the Supreme Court, can do that. This distinction is critical. They are saying you can keep the arrest, but you cannot keep the trial going on the old terms. By conflating the two, the court allegedly committed a judicial ambush. The language used by the defense team is unusually harsh, which tells you how angry and confident they are. They describe the ruling as judicial rascality taken too far. They allege that what happened on November 20 was not a trial, but a script that was predetermined. Njoku claimed that the court chose convenience over law and politics over justice. This accusation of political bias is heavy. It suggests that the judge was under pressure to deliver a conviction at all costs, even if it meant breaking the rules of the legal profession. They are warning that if this judgment is allowed to survive, it sets a precedent for tyranny, where any Nigerian could wake up tomorrow and convicted under a law that was abolished 10 years ago. It creates a legal anarchy where the courts become co-agents of government reprisal rather than arbitrators of justice. If you are finding this breakdown of the legal battle insightful and you want to follow every step of this appeal as it moves to the higher courts, please take a second right now to smash that like button and subscribe to the channel, because we bring you the details the mainstream media often misses. The defense team has confirmed that they have already filed the appeal, and they are not just hoping for a reduced sentence, they are expecting a total discharge. They expressed optimism that the Court of Appeal will overturn the conviction because the error is so glaring. Njoku added a profound warning. We trust that the higher courts will correct this embarrassing distortion of the law. But even if they do not, history has already taken note of what happened in broad daylight. This is a challenge to the judiciary's integrity. They are putting the appellate judges on notice that the world is watching to see if they will uphold a dead law or uphold the Constitution. This legal confidence also feeds into the political narrative we have been tracking. Remember Governor Alex Otti's visit to Sooto and the talk of a political solution? While the politicians are working on a pardon, the lawyers are working on an acquittal. If the appeal court agrees with Njoku that the trial was a nullity, then Nnamdi Kanu doesn't need a pardon, he needs an apology. An acquittal is far more powerful than a pardon because it says you did nothing wrong in the eyes of the valid law. A pardon says you were guilty but we forgive you. This is why the legal team is fighting so hard even while the political talks are ongoing. They want to vindicate him, not just free him. The defense team also touched on the issue of double jeopardy, which is another legal concept that might free Kanu. They cited the Supreme Court's previous handling of the case, arguing that the Apex Court's decision to remit the case back for trial in December 2023 was erroneous and a jurisdictional nullity because it ignored the fact that the Court of Appeal had already discharged him in 2022. They are building a case that Kanu is being punished twice for the same alleged offenses, which violates Section 36(9) of the 1999 Constitution. Njoku described the ruling as vindictive jurisprudence, sending a dangerous message that the state can bring him back and try him again until they get the result they want. This relentless pursuit, they argue, has turned the court into a weapon of the executive branch rather than a shield for the citizen. We must also consider the Sooto factor in this appeal. Kanu is currently in the Sooto Correctional Center, a transfer that was part of the consequence of this disputed conviction. If the conviction falls, the justification for holding him in a maximum security prison in the northwest evaporates instantly. The lawyers are effectively fighting to unlock the gates of Sooto with a key made of pure law. They are telling the Nigerian public to read the law and demand accountability, insisting that public ignorance is what allows judicial abuse to thrive. They want every Nigerian to pick up the 2022 Terrorism Act, read Section 97, and see for themselves that the judge had no power to do what he did. It is a call to intellectual arms, urging the citizens to become the jury in the court of public opinion.
So, as the Court of Appeal has set the 8th of December for this historic battle, the atmosphere has shifted from despair to defiant hope. The life sentence that looked so final last week is now looking like a fragile house of cards that could collapse with one push from the appellate court. The defense team has drawn their line in the sand. A dead law cannot kill a living man. The question now is whether the justices of the Court of Appeal will have the courage to agree with them and deliver a judgment that could embarrass the government but save the judiciary's reputation. What do you think? Is the defense team right that the dead law argument is a slam dunk? Or do you think the government will find a way to justify the conviction at the appeal court? Let me know your thoughts in the comments below. We will keep you updated on every motion, every affidavit, and every ruling in this case of the century.